Madam Clerk.
This Honorable Court of Appeals is now in session.
Thank you. Good afternoon to the attorneys. I understand that the time has been reserved for rebuttal. Also, if there's anything that occurs regarding your reception or you're doing these proceedings, please let us know immediately. We would proceed as if we were in court, except you will not need to stand during your presentation. Okay. Madam Clerk, are there any motions or any preliminary matters we need to consider?
No, Your Honor.
And we'll hear the appellant. Yes, sir.
May it please the court, Bryant Kroll here on behalf of the appellants, Rachael Green and Logan White. Your Honors, this case essentially falls upon whether or not the child at issue, ZWG, was in the care or custody or control of DCS for purposes of jurisdiction of the Claims Commission below. This court's held in prior decisions that care, custody, and control is actually read in the disjunctive, such that a child could be in the custody of another party outside of DCS custody, but DCS may still owe a duty of care or may still have control over that child. This is that case. What distinguishes the case at bar from Mullins, which the state relies upon, is that in Mullins, there was a report from the parents that came after the fact, after DCS had engaged in a voluntary or a temporary custody order. And afterwards, Ms. Mullins complains about the environment that the children are in. There is an investigation, and the investigator found that the allegations were unfounded. In this case, prior to the placement, there was an investigation, and the investigator informed the DCS agents who were negligent here that the house was in a deplorable condition, that they should not be placed there, and that, in fact, if the children were found in that home in Warren County, that they would be removed. Now, ZWG was placed in the temporary custody of the Matuzovics pursuant to an immediate protection agreement. Now, this was essentially a voluntary agreement that we find out could have been revoked. Now, Ms. Green never knew that it would have been revoked or anything of that nature. But at the time and throughout, up until this order, we'll just assume that the temporary custody order, or what's actually titled the order resetting adjudicatory hearing in this case, which the state contends is the point at which custody was transferred. Even up until that point and through that point, what has been alleged in this case is that DCS still had a duty of care to these children, or to the children in general, and specifically to ZWG. Attached to the complaint, we had the separation notices for Kaylee McSwain and Cicely Dixon, the two DCS agents who failed entirely to follow any of the DCS protocol in this case for the safe placement of children. And these duties included the duty to confirm the safety of the grandparents' house pursuant to DCS policy 14.9. And they didn't follow that. They didn't, even after they were made aware of these deplorable conditions within the house, they didn't follow that at all. You take the fact that the children would have been removed if they were found inside the house. That also, it's our position, creates a duty and demonstrates that these children were still within the control of DCS. Had Cicely Dixon or Kaylee McSwain done what they were required to do, which was perform a face-to-face visit, follow up on the what they called the non-custodial expedited placement assessment that was never finalized. If there were signatures that were needed to be obtained on that document, then that would have resulted in the children being placed, not being placed in the home simply because there had been no signatures. So we have, in this case, unlike that in Mullins, numerous duties and that were owed to the children that were foreseeable that this would result in what would be a asphyxiation from co-sleeping in an unsafe environment. But in Mullins, essentially after the temporary custody order, there was no more duty. And specifically in that case, a DCS agent had testified that once there's a temporary custody order, the DCS is essentially not involved in it. And that's what's distinct from this case. One, we haven't had any testimony because this was decided on a Rule 12 motion. Second, to the extent that testimony was found in that case, that's unique there. But here we have allegations in the complaint as well as in the attached separation notices for these two workers that demonstrated that they still had an ongoing duty of care and the ability to control the outcome of this case. And because they did nothing, it resulted in the death of ZWG.
These workers, were they chastised for not following their duty or anything like that?
Your Honor, they were more than chastised. They were both terminated. And the termination notices are attached to the complaint. They're in the record starting at 96 in the record throughout. They're very lengthy notices that detail the multitude of failures in this case that would have resulted in the children being, at least at a minimum, what they should have never been placed in the Matuzovics home. But certainly if they'd followed up on any one of these duties, a face-to-face visit, an assessment, any of these things that they were required to do, it would have resulted in their removal. And regardless of the order that came down, the order resetting the adjudicatory hearing, and it's our position that second point of our brief that ZWG was mentioned in the caption, but no particular allegation in the petition for dependency and neglect even applied to him. The state takes the position that within the I think it was actually in the immediate protection agreement, that the children, all three children, require care and supervision, but ZWG was an infant. Of course, he requires supervision and care. The only allegations in that petition involved alleged abuse between two of the older children who were developmentally disabled, but there was no allegation specific to ZWG, and his placement was voluntary, and DCS certainly had a duty to follow up on any one of these things, and they didn't. And essentially, that is what these two workers were terminated for. Both of them are very similar because from what I understand, one was a lower level worker and the other was a supervisor. So you have two levels of failures here on DCS part, failure to supervise and a failure of the actual agent to even drive over there because I believe she'd said it was too far to drive. And
excuse me for interrupting, counsel, is the nature of the cause of action one for negligent investigation?
It is not, Your Honor, no. That in State v. Mullins, there is no claim for a negligent investigation. Here there was an investigation and it wasn't negligent at all. It was actually directly on point. CPSI McSwain, I believe was her name, from Warren County had said, do not put these children here. In fact, this is so bad. If we were to find the children here in Warren County, we would remove them. And knowing that situation, and we have attached the photographs to the complaint, and some of them were cited in the brief, but that was found to be the same quote unquote deplorable condition that these children were, or that the house was in when these children were placed there. And so this is as distinguished from Mullins, where there was a report from the mother after the temporary custody order. In that case, after the fact, she makes a report, requests a referral, I believe they call it, and there was an investigation. And they alleged that essentially they failed to do an adequate investigation. So that obviously isn't a claim enumerated under the Claims Commission statute. But what is enumerated is care and control. And what we have here, even if there may not have been custody, we certainly have control and care, those two, because of these duties that the DCS workers owed for face-to-face visits. And there's no question that they were required to do that. And they didn't do it. And any one of those could have resulted in the children being removed at any point in time, and it most certainly would have saved ZWG's life.
Does
Because
CS have the power to remove these children?
they did. The CPSI McSwain, the one from Warren County, who said don't do this, she said if the children were found there in a house in that condition, they would have been removed. So it stems from that fact that if excuse me, I think I said McSwain. Kaylee McSwain was the one that was terminated. The one from Warren County, beg your pardon, Your Honor. But if McSwain had gone out there and done this face-to-face visit and seen these deplorable conditions, she had a duty to remove them according to these termination memos that were attached. So at that point in time, if they'd followed through with their job, then they would have had a duty to remove. And so that falls within control.
Is it your client's position that the juvenile court orders only related to the other two children and not this child?
It is, Your Honor. And what we had, and this was a first for me, but on a motion to dismiss, they filed things outside of the pleadings, and then we filed our own declaration from the guardian ad litem, who said that these proceedings were not specific at all to ZWG, and the context of the orders and looking through the language of the orders, he is only mentioned in the case caption. And then there's some references generally to the children, which adds a little bit of ambiguity to it, but it appears that most of these juvenile court orders were forms that were filled out. But
excuse me for interrupting, do the juvenile court orders name the other two children or just generally make reference to the children?
So that all three children were in the case caption up at top. Inside the body of the petition itself, it specifically mentioned DG and AS, the two older minor children. So there were specific allegations as to the others, but there was not a specific allegation as to ZWG.
Thank you.
And yes, we would contend that with regard to the lack of specific allegations or even a referral, what they refer to as ACV or alleged child victim, without ZWG being an alleged child victim, that petition doesn't pertain to him specifically. And so the case caption is not determinative of what that applies to. So it's our position that his name in the caption, for the reasons we stated in our brief and what Sonia Boss testified to as a guardian ad litem, that those proceedings were specific to the two other children, but it's the DCS policy to include them all, regardless of whether there are specific allegations. Thank you.
We have time for your rebuttal. For the appellee.
Thank you, Your Honor. Good afternoon, and may it please the court. My name is Andrew Womack, and I'm an Assistant Attorney General before you today on behalf of the state of Tennessee and the Department of Children's Services. Although this claim involves the tragic death of a minor child, it does not involve the state of Tennessee, as the Claims Commission correctly held that it did not have subject matter jurisdiction to hear those claims because the child was not in the care, custody, and control of the state after the April 18th and May 9th, 2018 orders by the Sumner County Juvenile Court. The state's argument here rests on two main points regarding the Claims Commission's holding. One, that pursuant to the juvenile court orders of April 18th and May 9th, the decedent child was in the sole custody of the Matusowiczes, and the state had no legal duty to control him or provide for his care. But also, two, that the decedent child was not in the care, custody, and control of the state even prior to the juvenile court orders granting custody.
Who chose this placement? Who chose the placement?
Under the non-custodial immediate protection agreement, Your Honor, the placement it's not a placement in terms of how DCS would take custody of a child and put that child in foster care. The child was placed with the Matusowiczes pursuant to claimant Green's own decision to have the children stay there because they were the paternal or are the paternal grandparents of claimant Green's middle child. So they were family members with whom claimant Green entrusted the care of her children. But it was not an affirmative DCS action that actually put the children in this house, nor did DCS remove the children from claimant Green's custody and then place them in a foster care situation that they had chosen these paternal grandparents to fill in as foster caregivers.
Did DCS have any connection with these children once they were placed in this custody?
Once they were given to the Matusowiczes via the IPA, that Immediate Protection Agreement, the IPA itself went on to dissolve after 10 business days by default, pursuant to DCS policy. DCS had no additional interaction with the children's stay up until counsel for DCS, Nicole Fisher, filed a petition for neglect and dependence and court-ordered services, which occurred May 1st, 2018. So a few weeks after the default dissolution of that IPA.
What obligation, if any, did DCS have once these children were placed in the custody of the Miloseviches? I may not have said that correctly, but once they were placed there, weren't there some responsibilities that DCS had, like some interview they were supposed to do, or some sort of follow-up just to check on these kids?
And if I'm understanding your question correctly, Your Honor, you are referring to the time prior to those juvenile court orders?
Well, I'm asking for both. For both time frames, before the juvenile court order was entered and then after. Did DCS have any obligations to follow up on the care of the kids?
After the orders were entered by the juvenile court granting custody to the Matusowiczes, it was no longer the responsibility of DCS to provide for the children's care, to provide for their well-being or control them. And that is pursuant to the Supreme Court's holding in Mullins that at that point, the state had no legal duty to control the child in Mullins, that point at which the juvenile court order was entered. Now, the question becomes a little bit murkier prior to those juvenile court orders. And in this instance, as stated earlier, the children were given to the care of the Matusowiczes pursuant to the non-custodial immediate protection agreement. And there is some evidence on the record that DCS was to be doing follow-up investigations, and that the two employees who were fired failed to meet certain DCS policies and guidelines in performing their duties. Of course, the state's position in that regard is, insofar as this court may find those to be claims for negligent investigation, negligent failure to follow policy, that those would not be claims properly before the commission. Despite that, the state would also posit that the children were not in the care, custody, and control of DCS even prior to those juvenile court orders. And this case is distinguishable both from Mullins and from the case In re Demetris that appellants have relied upon. First, because unlike Mullins, in this instance, there was no DCS removal of the children. In Mullins, DCS did quite literally take the children from the parents, take on legal custody of those children, and then place them in foster care as it was defined by statute at the time. Now, the non-custodial IPA does neither of those things. It is not a legally binding document. It is revocable. It does not establish any particular objectives that the parent or guardian need meet before they may affect the return of their children. And instead, the voluntary agreement keeps control within that parent or guardian. In this case, claimant Green. And it also reads at the bottom of that form, reiterating that it is revocable at any time. And please contact DCS, or in this particular instance, the caseworker, if there is a change to the children's living situation, which on its face indicates that DCS did not have control over these children or control over whether or not they were staying with the Matusewiczes. DCS was asking the parent or guardian to please let them know if a change did occur.
Is DCS a party to the IPA?
Your Honor, the IPA is written in consultation with DCS, and it's in the record, Technical Record Volume 1 on page 65. You can see at the top, you have the family name, in this case, Rachael Green, and the case manager name, in this case, Kaylee McSwain, as counsel for appellants was discussing earlier. Being a party to the document, the state would submit no, not a party insofar as it's not a legally binding document, but the document is made in consultation with a DCS caseworker.
And even though it's a voluntary document, I'm trying to understand the landscape here. Does DCS not have the authority to say no to that placement? And isn't that what the person who actually went out and saw the house said? They said, no, this is not an appropriate placement. And could not DCS have said, we don't approve this placement?
It is possible that there may have been more invasive means by which DCS could have sought legal custody of the children, removed them from either claimant Green's custody or removed them from the custody of the Matusewiczes in this instance. But that wasn't actually the case because they never had that legal control over the children in which to do so, and is the very reason that the IPA is utilized in order to be the least invasive, least restrictive means of trying to help parents in need figure out what harm factors the children may face and either mitigate those harm factors or take the children away from the harm factors. But under the operation of the IPA at the time, it did not vest DCS with the authority to simply take the children and place them in foster care. Additionally, Your Honors, the facts here are a far cry from the facts that this court observed in the Inri Demetris case, upon which it did find state care, custody, and control. This case is cited by appellants in support of distinguishing the present facts from Mullins. However, there are a few facts that are quite different from the present situation. First of all, in the Demetris case, there was no juvenile court order that extinguished the state care, custody, and control that existed in Demetris. To the contrary, the IPA that exists in this case is not the same as the relationship that existed between DCS and the parents in Demetris. DCS actually required the parents in the Demetris case to take specific actions and meet certain objectives to affect the return of their children. Additionally, DCS refused to return the children to the parents' care in Demetris on two separate occasions, wherein the parents contacted the caseworker stating that the children were no longer safe and that they would either rather have the children returned to them to find a safer placement or for DCS to take the children and place them in a safer placement. But unlike the Demetris case, claimant here was not required to take any specific action with regard to her children. The IPA didn't require anything from claimant to meet specific objectives in order to secure the return of her children. Simply, claimant could have revoked this IPA at any time, and further it dissolved by default on February 13th. Under these circumstances, DCS did not control the child's living situation with the Matusowiczes, and instead claimant Green actually controlled them staying with those two individuals.
Mr. Womack, how does the IPA come to exist in the first place? Like, how does that get initiated? I assume the parent didn't just volunteer, just go to DCS and say, I need help with my kids, or maybe she did. I just don't know.
The facts in this case, Your Honor, begin January 25th, 2018, and that is when DCS received a referral regarding possible physical abuse of the eldest child. And then following that referral and consultation with DCS, claimant Green entered into the IPA on January 30th, 2018.
So if DCS gets a referral like that, do they investigate to determine whether it's been substantiated and then try and negotiate an IPA, or do they, I mean, is it an IPA or you lose your kids?
That would take speculation from me, Your Honor, regarding this case. But there would have been an initial investigation and consultation with the parents when DCS receives a referral. And then, to be the least restrictive, least invasive means, if it's possible, the IPA will be utilized instead, rather than simply initiating a litigation, initiating something in court to take the children from the parents and place them in state custody.
It's a faster and more efficient way to get a child out of a home where there may be dependency and neglect, as opposed to initiating a DNN case and going to court. This is a different way of achieving that while keeping, well, it's a different way of achieving that goal.
That's correct, Your Honor. It is a different way of ultimately trying to achieve the safety of the children that may be dependent and neglected.
All right.
As a final argument, Your Honors, the state would posit that even if this court does find that there was state care, custody, and control in this claim prior to the juvenile court orders granting it to the Matusowiczes, that no alleged state negligence was the proximate cause of the decedent's death. Claimants allege themselves that the proximate cause of the child's death was co-sleeping with Mrs. Matusowicz. So if the court does determine that care, custody, and control existed prior to the court orders, then this case would be akin to Mullins insofar as this court's analysis of proximate cause is concerned. In that case, this court held that the proximate cause of death was apparently the actions of the caregiver in Mullins, as opposed to anything that the state may or may not have done. While theoretically an argument could be made that the actions of DCS were, to some extent, responsible for the child's death, the rule is that where two distinct causes, unrelated in operation, one of them being the direct cause, and the other furnishing the condition by which the injury was made possible, the former alone, that direct cause, is to be regarded as the proximate cause of the result. And that was
I understand the issue on appeal is jurisdiction. Is that correct?
Yes, Your Honor, that is the issue on appeal.
Thank you.
Thank you. You have your rebuttal? Yes, sir. We don't hear you. You got your mic muted. Unmute your mic.
Thank you, Your Honor. I knew I was forgetting something. I'll address some of the points raised by counsel. There's in paragraph 2 of the complaint, we state that this IPA was entered into at the behest of Kaylee McSwain. I probably could have emphasized that, but behest means order. She was ordered to enter into this IPA. Had the case been able to develop through discovery, we probably would have found that this is essentially what amounts to a gun to the head of most parents who are facing removal of their children. Sign the IPA or else. I don't think there's many options given to these people, and there certainly wasn't any option other than this IPA given to Rachael Green. That's alleged in paragraph 2 of the complaint. So placement here also, I mean, that in and of itself, placing a child into a home, removal from Miss Green's home denotes control and care. And you have in the In re Demetris case, this court was discussing things about how DCS was heavily involved in the child's life, and they were heavily involved here. The IPA itself, or might have been the petition itself, discusses how the state has been involved in these children's lives. So in that regard, this is closer to In re Demetris than it is Mullins. And again, here we have the obligations essentially prior to this order resetting adjudicatory hearing. And I'll point out to this court that we don't have a final order in this case. There's nothing in the record about a final order. So it would be our position that DCS still retained control and they still owed these duties. They still had to do a face-to-face meeting. They had to do this temporary safety assessment. That there were a multitude of obligations that these DCS agents had throughout this case. There was nothing that cut off the custody or anything. There's no final order. There was nothing of that nature. The best that they had was this order resetting adjudicatory hearing. But again, for the reasons we've set in our brief and the reasons today, DCS still had an obligation. They still had the ability to remove ZWG, and they could have prevented this from happening. And just briefly, in terms of proximate cause, DCS was specifically aware of the safe sleep protocol for children, and in fact had a duty to make sure there was a crib. The pictures of this house that are attached to the complaint in the record show that there was nowhere to sleep. This home looked like it belonged to hoarders, and DCS took ZWG out of a home from where he was safe, may have been messy, and they threw him into a known danger and caused his death. Thank you.
Thank you. I want to thank both the attorneys for your presentation. Your case has now been submitted to the court. You will receive our opinion within a due course of time. Thank you very much. Madam Clerk, will you adjourn court until our next setting?
This Honorable Court of Appeals is now adjourned.
Thank you, Your Honor.
Attorneys may be excused.